We'll let them in. Okay, good evening and welcome to Tuesday's online seminar. Tonight, it's the latest in our Case in Point Live, presented by Mohammed Haque, who is a barrister, consultant barrister, adjudicator and quantum expert at Fletcher Day, and as always is happy to share his wisdom with us. As always, if there are any questions, please don't hesitate to ask these via the Q&A or chat facility in the bottom toolbar, and Mohammed will get to these at the end of the presentation. Alternatively, if there's something you'd like to ask but not in an open forum, please feel free to email him directly. You will see his contact details on the screen there. It's mohammed.haque@fletcherday.co.uk. He's always happy to answer any queries for you. So without any further ado, Mohammed, I will hand over to you.
Right, thank you very much, Julie, and welcome to anyone who's attending this evening webinar. This I never had an intention to do, this particular case, but of late I was told by a friend that another friend was involved at the High Court level and as well as at the Court of Appeal level for the appellant who won the case as a counsel. And that friend requested me to give it a read, and I did. And I found I was a bit fascinated, by reading through. This is around the time when Michael J. Lonsdale Electricals v. Bresco, or in short, as you call it, the Bresco's case, was decided. This is the first application of Bresco, and we'll see how interlinked these two cases are. And this one reached Court of Appeal. So there was an adjudication. Adjudication was decided in favor of the claiming party. The responding party refused to pay the sum. The claiming party was in liquidation, and obviously the claiming party went to enforce it to the High Court on a Part 7 claim, and they were refused. Being aggrieved and dissatisfied, the appeal was dismissed. So no enforcement of an adjudicator's decision, though the decision is valid. That's the interesting point. If you are familiar with Michael J. Lonsdale v. Bresco, or in other words, Bresco's case, it will be of interest to you. It's multidimensional. It's to do with insolvency. It's to do with adjudication, and it's to do with construction. However, my main focus will be on adjudication and, of course, construction. I will touch on insolvency as well, off and on. Now, because we are talking about a case law, I prefer to bring in front or up front a reference to the English doctrine of precedent, which means stare decisis. So the higher binds the lower. That means every single case, if it's done by a court and there is a judgment, it's a court of record, then the lower court will be bound by it. Regarding a court of same hierarchy, the previous decision is normally not bound, it's of persuasive authority. However, only the ratio decidendi of the case is binding, not those reasons which the judges, because argued before them or because they felt it needs to be addressed, even though not on an issue directly, addresses within their judgment, but didn't form part of the reasoning on which the outcome was or the case was decided. So that's obiter, passing remark. However, if you are familiar with the English doctrine of precedent, the famous arbiters of the higher courts of like Court of Appeal and House of Lords, as it then earlier was, or the UK Supreme Court, as it now called, are of immense importance and used various ways to develop case laws and subsequently applied many a times. The most famous example, if I want to bring from the history, it always comes to my mind, is the case Hadley Burn and Heller and Partner, in that the House of Lords, as it then was, now called UK Supreme Court, decided that there is in existence a claim for pure economic loss due to negligent misstatement. And that's a ground for negligence in contract as well as in tort. Having said that, House of Lords also decided that because there was an exclusion clause, the party who advised would not be responsible in that case. So the entire judgment, that part of the judgment, which affirmed or stated for the very first time so clearly that there is a cause of action known as negligent misstatement, either be it a misrepresentation under the contract or negligent misrepresentation as a contract, or under the tort of negligence for pure economic loss, was not available, and it was a mere dicta. However, as we know, that a branch of law of tort has been developed under the doctrine of negligence due to that. So why am I talking about so much on obiter dictums? Obiter dictums because we'll see today, the discussion we're going to have, the Court of Appeal judgment of this case, almost 9/10 of it is obiter. So the Lords, the Law Lords, Lord of Appeals in Ordinaries, His Lordship, Mr. Justice, Lord Justice Colson, delivering the leading judgment, with whom another Law Lord concurred, Lord of Appeal in Ordinary concurred, and the other one added something but didn't differ from the conclusion itself. So more or less a unanimous judgment, but was disposed of on a single count. So everything else what has been stated were obiter, but of immense importance for those of us who are doing practice in the sphere of adjudication and construction, as well as insolvency. As I said earlier, I'll be less involved in insolvency, more in the adjudication and construction today. Now, I would like to bring one more thing. The name of a case, I'm not going to discuss it in any detail. It's called Young v. Bristol Aeroplane Company Limited. It says it's a case of, as you can see, it's of 1944, quite an early case. And it's a case where it's been discussed the effect of a case decided by Court of Appeal Civil Division. The rule is the High Court is bound by it, unless some exception like parent curiam or factual distinction can be drawn. The Court of Appeal is also bound by it, normally, unless one of the exceptions, like there were two contradictory previous decisions, like it contradicted one of the decisions of the House of Lords pre or post, or it was parent curiam. So what I'm trying to say here is this decision, although obiter is persuasive on most points, at least on one point on which they upheld the decision of the High Court. That's shortly called a security point. This was a ratio dissidenda of the case, and that's binding upon both the High Court as well as the Court of Appeal, unless one of the exceptions to the Young and Bristol Aeroplane Company can be established. If that's the case for High Court and the Court of Appeal, you can imagine the situation for adjudicators and adjudication practitioners or insolvency practitioners or insolvency tribunal, it's all binding for them. So it's a pretty important case. First application of Michael J. Lonsdale v. Bresco, an interesting one. And also, I would say it's far more important for the professionals to go through this. It's a must read for anyone who's in this profession, and to take steps properly. If in this case instant, the professionals took proper steps, they could have saved the disaster as it happened. So let's now get into it and discuss. Well, of course, as I said, it's just as a Bresco's case, this is all about adjudication and liquidation. We don't need to say it again, or needless it is to say that earlier decisions have been set aside, and they, in an emphatically important judgment, the UK Supreme Court has enunciated last year that any party who's in liquidation can adjudicate and can be adjudicated against. Now, the same type here as well, John Doyle Construction Limited was in liquidation, unfortunate company. This was a subcontractor of Erith Contractors Limited, regarding building works or construction works in the 2012 Olympic Games for the Olympic Park. It was about hard landscaping work subcontracted to John Doyle Construction Limited. And before 2013, sometimes in 2012, late 2012, John Doyle Construction Limited entered into administration. And then in around June 2013, the company went for a creditor's voluntary liquidation. So this is a case, the dispute has arisen back in 2012. Much of time elapsed and nothing happened. By the accounts and the books and the contracts of John Doyle, there was no settlement of a final account with Erith Contractors Limited, and John Doyle thought, okay, we're going to bring an adjudication. So they brought an adjudication in 2018 for the valuation of the final account, which they said was circa £4 billion. Adjudicator took months and months and months to decide it, and eventually decided it. Both parties were very aggressive in their submissions, as usual. Many a times we see as an adjudicator that people do it. Well, I represent parties in adjudication as well, but I don't find it any reason to be unnecessarily aggressive because, or why did you say it earlier? Why you didn't say that earlier? That sort of thing, you know, and they're shooting themselves at their feet and all these nonsense, because, you know, adjudicator is not going to be at all worried about these sort of things. He's only thinking what is legally correct and what is quantum was correct. So anyway, the adjudicator took time, but came to a decision that John Doyle is going to get 1.2 million. And as we know, that's adjudication. This was an NEC3 contract, though, amended form, bespoke, because it's been amended heavily. But under an NEC3 suit, the adjudicator found that John Doyle was entitled to 1.2 million. That includes VAT and interest, so something about £700,000-800,000, I would say, in real term. So not for, I mean, I don't know whether 4 million is gross or the ultimate claim, but that was what been awarded to be paid to John Doyle. And not surprisingly, Erith said, I'm not going to pay. Okay, I'm not going to pay, despite that the adjudicator has decided that you're entitled. I'm not going to pay. And well, I don't know if I've missed one point, but I would prefer to refer to that point right at this point. It might be it's referred to in a later slide, but I just feel like it's the best idea to refer that point I wanted to discuss that right at this point, which is I would call it John Henderson point. So John Henderson is a solicitor, maybe a sole practitioner, and he started a litigation or ADR funding company as well. So John Henderson buys or used to buy claims from other people who can't pursue it or who do not have the fund to pursue it. You know that if you win a case in adjudication, if you win an adjudication, the fees of and costs and expenses of the adjudicator is borne normally by although there isn't any hard and fast rule as such, but normally the adjudicators follow the rule that the losing party should bear the burden of the cost. So that's been paid, but it could so be that you don't have the money to even pay for your representatives or have the appetite to compile a claim. So there is a cost involved for a party representation, and unless there is an agreement beforehand, you are not entitled to recover the amount. So maybe that's the reason why the liquidators of John Doyle never ever thought of going to adjudication. But then John Henderson convinced them that they can sell the claim to him and he will go and start the adjudication, enforce the decision, and then get his cut. It was decided that initially John Henderson will pay John Doyle a sum of 6,000 something. I think 6,540 was paid in. And if the claim was successful, then in total, John Doyle will receive 45% of the proceeds, and 55% of the proceeds will be taken by John Henderson. Now, they had entered into, to sell the claim, they had entered into, meaning John Doyle and John Henderson entered into an agreement, but the main contract between John Doyle and Erith never permitted John Doyle to assign anything. So they didn't have the right to assign the claim under the assignment agreement they purported to do unless Erith consented, and not unusually Erith said, no, we're not going to give you the consent. So this was not a legal assignment at all possible, but in equity, they had an agreement. No one can stop them to agree to that there will be an adjudication brought in. The name will be John Doyle, but it will be funded by John Henderson, and everything will be done by John Henderson. And then if there is a win, apart from the first 6,500 whatever, John Henderson will get 55% of the proceeds, and John Doyle will get 45%. So in other words, 45, 50, giving out the VAT is going to still be a split of good part of almost £500,000 sterling. So interestingly, John Doyle bought the story. They've gone with hand in hand with John Henderson, and we'll see that also played a part eventually, though not so obviously, but played a part for the court to decide against John Doyle, because I had a feeling that time and again this issue was discussed. Of course, the responding party, who was the appellant before the Court of Appeal, Erith, Erith's counsel said it's tempestuous, meaning that this is illicit an agreement to fund proceedings and to gain from therein, and as such should be declared void, and on that ground alone no enforcement should be there. However, that point didn't sort of need to be considered in any detail. But reality was, when the refusal came that they're not going to pay, John Doyle started a CPR Part 7 proceedings. We know that if you are in an adjudication, if you are seeking money and you have been awarded money, then there is a bespoke procedure in front of the TCC. You can go and enforce it within 28 days of you initiating the case of enforcement. A hearing will be held. Summarily, a judgment is given unless there is a complex issue of evidence involved, where the judges then ask to go for a trial. Now, this is what has been done. There is an alternative in Part 7 if your claim is a matter of declaration only, but that's more or less was the situation. And what happened, that it was originally scheduled to be heard on the same day. On the same day, the Supreme Court was handing over the judgment of Bresco Electrical v. Michael J. Lonsdale. It was the same day, it coincided. So given that this would or had a potential of determining the fate of this case, His Lordship Mrs. Fraser decided to hear the case later than this Bresco v. Lonsdale will be decided. And he did, he deferred the hearing, and he only heard it in July, and Bresco was decided in June. So he was the first one who was distilling and applying the principles that governed a party in liquidation seeking to enforce an adjudicator's decision in his favor by of a summary judgment to enforce the adjudicator's decision in summary proceedings. So it was not a full trial or something like an extended trial to go to court and to have it enforced. It was a summary proceedings application specially devised by TCC for such a case. And that was then heard in July. And in October, the judgment was handed over. And the order was dated 9th of September, wherein Lord Justice Fraser has preferred to reject the case and favored the responding party. Now, why did he refuse to enforce? That's the key question, you know, we are going to consider today. First of all, there is no doubt now that if you are a liquidating party, you can start an adjudication, or an adjudication could be started against you. So whatever the implication of the earlier decisions are, it's no more valid. Okay, so that's not a problem. But interestingly, the question came forward that can a liquidating party who has two parts, let's listen very carefully at this point, that can an adjudicating party, a claimant who's in liquidation, has, if has a decision in their favor from the adjudicator, ever, that's the most important thing, ever enforce that decision provided or pending the net balance or set-off procedure under the Insolvency Act. So we've discussed it at length, but I'll touch upon this just to refresh our memory, that as soon as a company goes into liquidation, if one of the creditors or one of the debtors have a counterclaim against the company, then under the insolvency rules, the parties enter into a proceedings called net balance or set off under the insolvency. So till that's decided, the effect of adjudication decision is that, okay, you are entitled to X amount, X 1 million, 1.2 million in this case. Okay. Now, Erith had the say that, well, I'm not entitled from you from other contracts and this, that, the other, such and such amount. So as soon as that's raised, it could either be a simple sum, not contested, counterclaim being made by the other side, then it's an easy thing, just plus minus, and we know what it is. But if that's not the case, then there is an insolvency, under the insolvency rules, there is a proceedings called net balance setting off that is started. Now, both in Michael J. Lonsdale and in this case, it's the same. And the first question was, can we adjudicate in a situation like that? And we know Michael J. Lonsdale v. Bresco has said, yes, you can adjudicate, regardless of what the decision of the net balance would be. Okay, you can adjudicate, you can get a decision, fine. But later on, we'll see today, there's a one particular aspect which I don't think Michael J. Lonsdale has ever mentioned and which has been discussed at length here. But the point is, technically, yes, you can adjudicate. And as far as if you're an adjudicator, you should be happy that you'll get your fees. Okay, you'll get your fees without any doubt. But I also suggest you that if you see a situation like this, you should, within your terms and conditions, write down a sentence that if either party becomes insolvent, because the fun is, as far as the adjudicator's cost is concerned, the parties are jointly and severally liable, provided he has a jurisdiction and he was not in breach of natural justice. So his position can be, and the third one is, was not at fault. Let's say he decided the case and published it after 29 days rather than 28 days, if the 28 days limitation applies. So these are type of thing, other than that, he's entitled to. But you make it sure to mention that the effect of insolvency or liquidation in your T's and C's, and especially take clearance from the party in liquidation administration already. So that's that. So coming to this point that has bothered the court, that would it ever be possible to enforce? Now, the general thrust we will see today is possibly no. And there are three different reasons for that. Unfortunate, but that was the general thrust of the discussion. Although, as I say, the case was decided on a simple thing, that the party who was seeking to enforce, this case John Doyle, didn't provide a clear, evidenced and unequivocal undertaking or security that how the concerns of Erith will be maintained if there is a problem in the net balance set off, or if there are more litigations coming up for their costs. So the decision actually turned on a simple point. Rest are all obiter. Now, first we'll consider this point of how the decision turned on, that's the ratio, and then the peripheral issues on this, which I'll call security issues, and then I'll discuss other issues of adjudication and stay of execution as well. Now, John Doyle pursued three grounds for the appeal, but Colson Lord Justice delivering the judgment said in obiter, the default position will be that even if we enforce, we will execute stay the execution of the enforcement order. Meaning, even if we say that, yes, you can enforce it, there won't be any money upfront. Now, why? That's the thing. Why? I'll go to that, but before that, let's come back to what happened about the security issue. The security, if John Doyle's counsel or John Henderson or their solicitors, I don't know if there was any other solicitor involved, had said up front that, okay, this is the bank guarantee. which, if there is, say you pay me 1.2 million, the VAT I might pay to, and that's another complication. VAT, I mess up with paying to the HMRC or anything. I'm not a VAT expert or not a statutory tribunal either. I don't know, but there will be an issue about the treatment of the VAT. But other than that, the VAT issue, the interest and the sum, whatever that may be, let's say it's 700,000 or 800,000. Now you take the money out, fair enough, but then if the net balance proceedings we are holding, that results into a negative thing for your favor, meaning that we, Erith, has the right to claim some money back, where shall we get the money? That was the first question. Answer would be, okay, I have this. Well, it could be a post-dated check, but that's not going to help because you're already in insolvency, you're already in liquidation. So it has to be a third-party guarantee. And a banker's guarantee that we will honor this check, regardless of whatever comes, might satisfy. Clean, unequivocal, and evidence clearly that this is the document of security we are producing. Unfortunately for John Doyle, they never done that. What they've done was, they have given an ATE insurance policy. I don't know if you're aware of what ATE is, but I think we should discuss it here. ATE is after the event insurance. It's quite popular. For example, you're a litigating party. Oh, well, although it's quite popular, I've never used it. So you can see some people are there who are against it. But ATE, what it does normally is, if you're a litigating party, that policy company comes to you and say, look, if you can't afford to pay your barrister's fee or some other charges, the court cost or whatever is within the policy, we're going to pay that off. Okay, and if you become successful, we'll recover it with a positive cut from the proceeds. If you're not successful, you don't have to do anything, we'll just pay off. Okay, to me, sounds too good to be true, because I need to work very, very hard to earn my living. So no one ever could buy me into this or bring me into this or rope me into this. I said, look, it can't be true. Maybe there is a trick which I'm missing, but I'm not interested. Now that sort of an ATE policy was tendered, and the policy that was tendered had loads of exceptions, as if this happens, you'll not get the money. If that happens, you'll not get the money type thing. Okay. Now, and then question of three things I've just pointed out, that the security you want to provide must be clear, unequivocal. So shouldn't be conditional on too many exceptions, and has to be, as I said, very simple and clear. 2-sentence. Reading through the judgment of the Court of Appeal, I had this feeling, please go through it. And also I would say, read through the judgment of Lord Fraser after I finish this, because if you find it interesting, you'll have enough kind of lead points to read it through now. That Lord Fraser was repeatedly asking the party, that is John Doyle, that show me a security you offered. There's a lot of aggressive discussions went on between you guys, the two parties, but show me the simple copy of a guarantee which ensures that in case the net balance goes against you and Erith is entitled to some money, or as Erith is arguing, that in case you then fail to, I need to get into a litigation and incur some more cost, their interest is protected in a single document. Okay, there was, God knows why, there was a letter of credit. I don't know how a letter of credit could come into this scenario. There was this ATE policy, which is itself conditional. And then why there was an appeal, during the course of the hearing, when Lord Fraser made it very clear that I can't see, despite 4 witness statements. The first one was 27-page, 126 paragraphs to explain to the court why it should be enforced. And Fraser Law Justice was Justice Fraser, His Lordship Justice Fraser was simply asking the question, give me the security, which is an adequate security, clean and simple, and of course by a banker or insurance company, AAA, plus, that in case you can't pay back the money you are taking today, that insurance company or bank is going to pay it. Show me this, end off. I will allow you. I will let you go. No, they give more arguments, more policies, and then finally orally saying into the hearing by the counsel that the money will be either paid by Erith into the court or in an escrow account. And the judges said, no, what is it? We don't understand. If they keep the money in their account, then why do you have to have it? What the point? What are you talking about? You know, what's the benefit of them paying the money? They're not insolvent. What's the benefit of paying the money into an escrow account and leave it till the net balance? You come back after the net balance. And when John Doyle, of course, underneath, John Henderson gone crazy and felt very agitated. Lord Fraser never bothered to raise their fingers and say that, look, don't forget, adjudication is only provisional. It's an interim remedy. You don't have a right in an ultimate scenario, a full right to claim that money. That money will be finally, and you will be entitled to if there is a litigation or an enforcement. So he said, even if I give you the enforcement, if you produce an adequate security, I will stay the execution of the order till the decision reaches finality. Very interesting. And it has this, a hard truth has come out because of the aggressive nature of John Doyle's counsel. So they appealed. Okay, in the appeal, they took the point, because they're in front of Lord Colson, of course. Lord Justice Colson is no joke. So they were very measured in their submissions, John Doyle. What they said, my lord, we accept that whatever His Lordship, Mr. Justice Fraser, said was absolutely correct. The security was not unequivocal. We couldn't evidence by providing a simple document, this is what we're looking for. And it was our duty to provide one. However, we're still pressing the point that our proposal that the money will be kept in a ring-fenced account will be, or should have been, the sufficient alternative. But reading Lord Fraser's judgment, it seemed that he didn't consider that point at length. That's how the appeal is tendered. Now, Court of Appeal took the view, it's none of our concern. It's not the duty of the court to assist a party who fails to bring on table what's required. It's your case, your enforcement, and he then discussed how things are done at TCC. So did Lord Fraser. That, look, you had a simple option. You could tender the document with a pre-action protocol type letter and say, this is the absolute guarantee we are providing, and additionally the money will be in a ring-fenced account, and let the insolvency proceedings come to an end. We'll have a net balance result and we'll take our money. One thing has not been said, and that's probably something, if you're an adjudication professional, will be helpful for you for attending today, this evening, is that why not adding, when you are entering into the contract, why not adding a finality clause of adjudicator's decision? okay, you'll save your client. If that was the case, the last point that was raised, that because adjudication is only provisional decision, we can't give a final, in a situation where you are insolvent, make it final for all material purposes, just because the net balance has been decided. Net balance is decided by taking into a provisional sum. That's not final. Mind you, if you are drafting a contract, please set a procedure through which the adjudicator's decision becomes final unless challenged, or if challenged, if been decided by the court or arbitration as valid. That's all from me. I think there might be any questions. If there is, then I'm happy to answer.
Indeed, there is. We've got a question in here. Someone's asking, what happens if a contractor was under administration before the contract was created and the contractor went into liquidation after the dispute arose? Can adjudication proceed?
Yes.
Short answer.
Well, I mean, well, if you are since Michael J. Launchdale and Bresco has decided that if the party in adjudication is in insolvency, under insolvency proceedings, or in liquidation, they can start an adjudication, right? It didn't limit that only the parties who were not in liquidation on the date or administration, which is of course a type of liquidation, on the date of contract, will be allowed to do so. Because Michael J. Launchdale v. Bresco is very, very clear that it doesn't matter. The material, sometimes as I used to practice administrative law, there's a concept of relevant date, So the relevant date, whether you're allowed or not allowed, is the date on which you're bringing the adjudication proceedings. And whilst you are allowed, even if you are in administration on that very day, you are allowed to go forward. So it doesn't matter if you are an insolvent a year earlier when you entered into the contract.
Okay.
I mean, let me tell you a joke about this, because why I could answer so quickly. There was this great Sir Isaac Newton, and he went to kind of a carpenter and said, look, make a cage for my dogs, give this side a big door, that side a small door. And the carpenter just did that. And then later on, when he was giving back the cage to Sir Newton, he just said, if you don't mind, sir, can you tell me why there are two doors in this cage on two sides? He said, you idiot, you don't understand. This way, the big one will get into, the other side, the small one will get into. And the carpenter said, cannot both get through the bigger gate? And Sir Newton was puzzled. He said, you are right. Bigger can serve the both. It didn't come through my mind, but yeah, it's just like confusion, like Isaac Newton, because if you can bring an adjudication on the day you are in liquidation, then it doesn't matter on the day of entering into the contract, you're in liquidation as well. Okay.
Well, thank you for clarifying that so beautifully, Mohammed, as always. Okay, we are back tomorrow morning. We have John Sharp with extension of time and proving delay. And then in the evening, we have Richard Silver with what is concurrent delay. So it's all about delay this week, it seems. And then finally, Thursday evening, we have Mohammed back with us for the next in his series about changes. So that is changes in construction contracts, the valuation and other implications. That's Thursday night at 6 p.m. So if you'd like a place on any of these or to log in for any of these, please email seminars@fletcherday.co.uk and we will add you to the list and send you the login details. Thank you again, Mohammed, for your time. Thank you, everyone, for joining us, and we look forward to seeing you all again very soon.
Sure. Bye.
Thanks, Mohammed. Bye.